consequences of the mineral royalty tax adjustments. The first one is that increment of 1.5% across the sliding mineral royalty tax band makes us as a country uncompetitive in attracting capital by pushing break-even times for mining projects. The second is that this is particularly disadvantageous since we have low ore mines relative to our neighbor, Democratic Republic of Congo. So Zambia at 5.5, up from 4% when prices are low, and 7.5 up from 6% at today's prices, and 10% at 7,500, above 7,500 per ton, I think puts us at a huge disadvantage in comparison with the Democratic Republic of Congo, because this is way over the DRC's rates when prices are good, and yet geologically Zambia's ore grades are a third of DRC's. DRC's average about 2% of ore grade. So this, in our view, puts the industry at risk, as of course our northern counterparts in the DRC are building capacity and reducing reliance, while we will effectively be becoming more beholden to them for ore to feed our smelters. You will note that we have in the past been importing ores and processing them to keep some of our smelters running. There are efforts, of course, by the Revenue Authority, where we've also noted some deficiencies in trying to ramp up revenue in the mining sector by introduction of measures such as mineral value chain monitoring mechanism. And we have on several occasions, I think, made recommendations to try and improve the mineral value chain monitoring mechanism by adding certain components to it, and we still await feedback regarding some of those recommendations. Moving to the Income Tax Amendment Bill of 2018, Proposal A, which is to limit deductibility of interest on debt owed by certain taxpayers. It's something to note here is certain taxpayers, meaning specific taxpayers. The move will lessen obligations in which taxpayers need to pay, which will improve compliance as taxpayers will not be strained. B, revise the kwacha to the United States dollar exchange rate to be used in computing index losses and indexed capital allowances for persons carrying out mining operations and keeping their books of accounts in United States dollar. Coming to C, make mineral royalty non-deductible for income tax purposes. Mineral royalty is a payment to the owner of mineral rights for the privilege of extracting the mineral from the ground based on the lease agreement. D, require business to which tax avoidance provisions of the Act apply to retain documents and other information relating to the business transactions for a period of 10 years. So this move, I think, allows for ZRA to access financial statements of institutions that have been found wanting for tax avoidance. So access to financial statements will provide accurate information on the amount of taxes due. This will therefore provide Zambia Revenue Authority with information to effectively charge penalties and taxes that are due. On E, authorize the Commissioner General to appoint the taxpayer as an agent to withhold turnover tax on payments made to suppliers of goods and services. This will promote compliance. At the same time, will help ZRA capture income taxes of companies within this bracket. F, introduce a presumptive tax on betting and gaming business. Betting and gaming businesses have continued to mushroom around Zambia. Betting and gaming businesses make excess profits as a gaming and betting firm, which is referred to as the house always wins. The proposed percentages highlighted in Part 3 of the amended bill are realistic and will generate more revenue for the government. G, allow an assessment in respect of transfer pricing cases to be made not more than 10 years after the end of the charge year to which the assessment relates. H, increase the maximum penalty that may be prescribed for non-compliance with transfer pricing regulations to 24 million kwacha from 3,000 kwacha. You will note here that the company transfers done internationally, which have tax advantages, has led ZRA to frown upon using transfer pricing for tax avoidance. I, on introduction of penalties for negligent, fraudulent or willful submission of an incorrect balance sheet, account or other document in respect of skills development levy under the Skills Development Act of 2016. The Skills Development Levy provides for the imposition, payment and collection of skills development levy, which Zambia Revenue Authority will administer under the provisions of the Zambia Income Tax Act of 1966. J, clarify that income of public benefit organization is only exempt from income tax if the public benefit organization is approved for the purpose of the minister. K, revise the current turnover tax and introduce a flat rate of 4% on businesses with a turnover of more than 800,000 kwacha or below per annum. L, on dispense with the classification of certain foreign earnings as income or originating from the exports of non-traditional exports, and provide for a maximum tax rate of 10% on income determined by the Commissioner General as originating from the export of non-traditional products from farming or agro-processing. Pmrc therefore would like to recommend that this notion be removed from the amended bill until a time where the country achieves its full potential in agricultural diversification. Reduce the company income tax to 15% from 35% for companies that add value to copper assets. N, increase withholding tax on dividends, payment or distribution of branch profits, payment of interest to a non-resident to 20% from 15%. Pmrc recommends the following: the need for policy consistency. The Act has been amended 4 times since 2012, which we feel is unacceptable given the nature of the Act, which seeks to maximize domestic resource mobilization. The contents of the amended bill should contain sections of all objectives for clear understanding. In order to enforce tax compliance, especially for VAT, many countries have introduced technological devices to enable them to monitor business to business and business to consumer transactions through electronic fiscal devices. So improving VAT compliance is one of the most critical issues for domestic revenue mobilization in developing countries for 2 reasons. Firstly, VAT revenues tend to dwarf all other tax revenue streams, so even a small improvement may have a relatively large impact. Secondly, the data generated to observe VAT liability generates a paper trail that strengthens the revenue authority's ability to enforce tax compliance across all domestic taxpayers. Therefore, the legalization of the use of electronic fiscal devices will boost revenue collection and simplify tax administration.
I want to get it from you. Did you investigate whether in other jurisdictions this is the case?
Our understanding, like you earlier mentioned, that there is actually need probably to try to increase revenue collection from the mine. So the aspect of treating the two tax regimes as separate, corporate income tax and mineral royalty, is an effort, I think, by the government to ensure that we collect as much revenue as possible.
Regarding the second question, where we're caught in between a rock and a hard place, I think it's more or less a double-edged sword. we are likely to see a situation where some mining firms would rather leave the ore in the ground as opposed to digging it out, because the cost of digging it out might be higher for them, and in comparison with our neighbors,